Coming from an experimental theater background, I always think when somebody stands out, you're doing something right.
There you go. I like that.
Okay, welcome back. I'm Cassandra Robertson, a professor here at Case Western. Our next panel is going to look at the role of medical professionals and mental health professionals. And with us today, we have George Annis, who is the William Fairfield Warren Distinguished Professor at Boston University Law School and School of Public Health. We also have Deborah D. Ascheim, who is the Associate Professor of Health Evidence Policy and Cardiology at Mount Sinai School of Medicine. And finally, our third speaker will be Stephen Reisner, who is Assistant Professor of Clinical Psychology at NYU Medical School. And we'll let everybody speak for about 20 minutes, most likely, and then at the end, we will take questions and finish up at 12:30.
Okay. Thank you. I consider myself a transitional figure between the last panel and this one, as I'm a lawyer, but I spend my life with physicians. And I am going to talk about military physicians, and I feel like I've spent a good part of my last 6 years talking with military physicians as well. My talk is really divided into two parts. The first part I'm going to assume most people know about, so I'm going to run through that really quickly. The second half, I'm going to concentrate on force-feeding hunger strikers and why that's been so hard to deal with. We've had, there's a new, been a couple of symposiums that the military has had lately on professionalism, and as you may know, they've decided they're not going to deal with Abu Ghraib and torture because that's clearly wrong, and no one's ever going to do that again. But they didn't, but they also going to ignore hunger strikers, force-feeding hunger strikers. And I'm going to make an argument that that's clearly wrong too. And almost all physicians know that. Nonetheless, even in the post-Bush era, even with President Obama saying he wants to close Guantanamo, we continue to force-feed between 20 and 50 hunger strikers every day, twice a day, at Guantanamo. And I want to try to figure out, I don't know why that is, but I'm going to suggest some things that we could do about it, and see, I can see what you think about it as well. Obviously, we know things changed at 9/11. Military medical ethics didn't change. In fact, if anything, these 2 volumes on military medical ethics were published after 9/11, and they're terrific. They don't have no civilian would find anything to complain about in military medical ethics. Military medical ethics go back a long ways. It has always been, Custer, a weird guy, but it's always been a court-martial offense for a military officer to tell a physician he or she couldn't, well, he almost always, historically, couldn't do their duty. Custer was court-martialed. One of his major charges in his court-martial was that he ordered a physician not to treat a soldier who was accused of desertion. He was found not guilty on that charge, but everybody agreed, including Custer, that that would have been an illegal order and that nobody should have followed that. We all know about Guantanamo. We're going to talk about that. We all know about Nuremberg. I don't have to talk about that, but I do want to highlight couple things in Nuremberg. Number one, you probably all know, General Halder and General Keitel testified at Nuremberg that Hitler said that they shouldn't follow the Hague Conventions in the war with the Soviet Union because it was, quote, a new kind of war, Hitler's words, and because the Soviets hadn't signed the Hague Convention with them. That's not an argument that Bush, using the same words, was like Hitler. It's an argument to say the Bush administration knew no history at all because they never would have patterned themselves on World War II. We know the Nuremberg principles. I don't have to go through those, but obviously obeying orders is not an excuse. Most important for this presentation, though, is the subsequent trials and the doctor's trial, the first subsequent Nuremberg trial, which was done with exclusively U.S. judges and following the international law that had just been decreed at the International Military Tribunal. It was prosecuted. The lead prosecutor was a military prosecutor, General Taylor, obviously, but his whole team were civilians, as you can see. That's the prosecution table there. And they were, whatever they were doing, they were certainly doing German law, since we were the occupier there, and American law, And now, most recently, the Second Circuit has said they were also making law of nations or international law. Much of the law was about experiments, what the limits are that you can do, and the Nuremberg Code came out of that trial, which requires, among other things, the voluntary, competent, informed understanding consent of the research subject. It was not an argument, as my colleague Bo Burt from Yale has said, that if they'd got consent in the concentration camps, it would have been okay to do the freezing experiments. That's not what the judges were saying. The judges were looking forward. How can we prevent what happened? What kind of structures can we put in place to prevent the kind of experiments that went on in the concentration camps from starting again? And just to emphasize, this was a military tribunal done under the command of General Eisenhower, and when General Eisenhower, it wasn't until General Eisenhower became President Eisenhower, actually, that the Department of Defense officially adopted the Nuremberg Code as department regulations, but not surprising. The shocking thing was, again, talk about people who don't know history, were the similarities between the photos from Abu Ghraib and the photos from World War II. And we've seen these before, and they're very powerful. All right. Now, how does this all relate, if it does, to hunger strikes? In the beginning of the Bush administration, one of the things the administration did was set up a bioethics council under Leon Cass. Very controversial council because they concentrated almost all their efforts on embryos and embryo research. And they did some reasonable work there. Well, we won't critique that. But one of the things they also did was to put together a set of readings, educational readings. And one of the readings was called An Account of Torture. And the account was of a Soviet dissident who's now in the United States, wrote about when he was in prison in the Soviet Union, was trying to support a fellow prisoner who was denied counsel, went on a hunger strike. And as a result of that, he was daily put in a straitjacket, dragged to another room, had a nasogastric tube jammed up his nose. And this was done to him over and over again over a period of 7 days. And the President's Bioethics Council said, this is clearly a case of torture. All right, this is inhumane. This should never be done. And we all know, of course, that the President or anybody else in the administration never asked the Bioethics Council whether it was okay to do force feeding like that at Guantanamo, because they know the answer they're going to get. There were on and off hunger strikers at Guantanamo almost since it was opened, but the big hunger strike, the one that more than 200 prisoners went on strike, was in 2005. And to try to respond to that, the Department of Defense ordered these restraint chairs, which have been designed and were in use in the United States to transport violent prisoners from the local jail to the mental institution. All right? That's why they're called, it's like a padded cell on wheels. That's the seller, the person that makes these, said that. 25 of these were ordered for Guantanamo. And you get the idea that people were strapped into these to be force-fed, and people on hunger strikes. Now, if Hernan Reyes from the Red Cross was here, he would spend a half hour, I'm not going to spend that much time, say, what is a hunger strike? All right? Because the physicians, and I've talked to lots of physicians about this, say, oh, well, we use nasogastric tubes all the time. We force feed people all the time in hospitals. All the time is a little extreme. They are talking about mentally ill people, mostly anorexics. And that's number one distinction. A hunger striker has to be mentally competent. Mentally ill people don't qualify as hunger strikers. Number two, you can't just be a food refuser. You can't just not want to eat or miss a couple of meals. He has to stop eating for declared purpose, and that he wants some changes made in the prison system, or he just wants to get out of prison. And then he has to remain competent, and then he can be classified, is classified as a hunger striker. All right. What do you do with hunger strikers? Hunger strikers are a big problem for prisons, big problem in the United States too, because hunger striking is so effective, right? What the hell is Julian Assange doing here? Just to remind us that the hunger strike protocol, what doctors should do in Guantanamo, is a secret protocol. It's not secret in the sense nobody's ever seen it. Julian Assange posted all the standard operating procedures at Guantanamo. That was his first post in WikiLeaks back in 2005. But it's been updated, and it is secret, and I would argue that there should never, ever be a secret medical protocol. That's just like contradiction to medical ethics in the first place. I've got Rumsfeld's new book, and Rumsfeld was very impressed with hunger strike and force feeding people while he was secretary. In his 850-page book, he doesn't mention this at all, even though there's a whole chapter on Guantanamo. And it's like a parallel universe. Anybody who's studied Guantanamo will not recognize anything that the secretary has to say about it there. But here's what he said in November 2005 when he was questioned about using these chairs to break the hunger strike. He said, and you all remember that, in the White House, when they were asked about torture, they all say, well, I'm not a lawyer, so I can't really comment on that. Bush said that, Cheney said that, Rumsfeld said that, Condi Rice said that, Alberto Gonzalez also said that, but we didn't know whether he was true or not. So what Rumsfeld said here, he says, well, I'm not a doctor, he says, and I'm not the kind of person who would be in a position to approve or disapprove of force feeding at Guantanamo. He said, it seems to me, looking at it from this distance, that the responsible people are the combatant commanders of the Army as the executive agent, and they have expert medical people who make decisions of that type. Right. And then he goes on and says, he doesn't take it seriously. He says, well, what's really happening is a number of people go on a diet where they don't eat for a period of time, then they go off that, and then they rotate. So it's clearly a technique to try to get the attention of you folks, the press, and they're successful, he says. So he doesn't take it seriously, but the most important point he makes is the main decision is the commander's decision. It's a military decision made by the commanders, and then the medical people enforce it, are told to enforce it. And that turns out to be true. And so one of the questions is, can medical people in the military use their medical skills for non-medical purposes? And the medical ethics after that is no, never. I mean, that was exactly what the problem was at Nuremberg, right? Now, the assistant secretary of the DOD for medical affairs was at that time William Winkenwerder, who had, I don't think he had any military experience, but I may be wrong about that. In any event, he drafted a whole new set of regulations in 2006 to deal with this. And they reconceptualized what was going on here as self-harm. And they said that the rule is that no inmate will be permitted to harm himself. All right. And at his press conference, again, this is June 2006, he said, we have a policy that is to preserve life. Oh, that's great. We think that people should not be allowed to starve themselves to death. And he specifically referenced the Shivo case. I mean, we're kind of left field. Is that coming from? But that was a big-time Republican case. As you may remember, the Congress passed a statute just to get Terry Shivo to have a new feeding tube put in. But if there's anything crystal clear in American law, is that competent adults have a legal right to refuse any treatment, including fluids and nutrition. Had to litigate that from Quinlan to Cruzan to Shivo. Anyway, that's like 9-0 in the Supreme Court. And that even when you're incompetent, we have to honor your wishes if we know what they would be, okay? That should apply. Well, actually, that's the argument. Should that apply as well to Guantanamo or to any detention setting? Again, I think the answer to that is yes. The military's answer, this is not public, but when you talk to the guys, they say, well, at that time they were saying, we don't want another Bobby Sands. We can't have anybody die in there because this would be way too powerful, and this would really hurt the cause, hurt the country. The World Medical Association, which was founded after World War II, has its own checkered history, and I've criticized them as well. Nonetheless, has spent more time thinking about this as a medical ethics issue than anyone else. They have three sets of more carefully articulated standards. The most recent one, again, 2006, seems like a pretty interesting year, right? Which was in direct response to the Guantanamo force feedings. Was that under no circumstances can a physician force feed a competent hunger striker? End of story. And even if you are doing assisted feeding for someone, you can never use it as punishment, and never use coercion, and never use restraints, any restraints, including the restraint chair. Right? That's hardcore medical ethics. And the most interesting thing about Winkenwerder and Rumsfeld and their use of the restraint chairs is I think this is true, I've never given contradicted in this, the first time in the history of the U.S. military that they have ever said physicians cannot follow medical ethics in performing their duties as a medical officer in the military. Obviously, many people thought that that was necessary, but that is such an amazing rupture in the history of military medicine that I, for one, think that it should not be permitted to stand, that it can't stand, that can't be the rule, that in order to be a physician in the military, you have to compromise medical ethics. Strikes me that the rule, and the rule always has been, that no physician in the military ever has to compromise medical ethics. But that's not the rule today. That's changed. And we have to get that, I think, we have to get that rule back. And the question is, how do you do that? All right? I don't want to do that. President Obama said the way he'd do it was to outlaw torture and to close Guantanamo. All right? And this is him signing the order to close Guantanamo within a year. That hasn't happened. All right, and lots of us have thought that everything would change when Obama became president. We're naive. I was naive. I thought he would actually close Guantanamo. But it's got to take more than just closing Guantanamo. That's important to do. But moving the guys at Guantanamo to the United States and then continuing to force feed them wouldn't be much of a thrill either. 2 points. Quit. Number one is the standard at Guantanamo. And Rumsfeld spends a lot in his book saying how shocked he was that Geneva applied to Guantanamo because his lawyers had told him it didn't apply to Guantanamo. And so the Supreme Court must have got that wrong, he thinks. It's a guy who thinks that, anyway, that he's not a lawyer. He thinks he actually understands the law at some deep level. The main point that is here is that Geneva obviously does apply to Guantanamo, and Common Article 3 definitely applies in all this. The President Obama, right after he became president, commissioned a study of Guantanamo and whether it was consistent with existing law. And I think that was a very flawed study. We can argue about it. I'm not saying Admiral Walsh did anything wrong. He's everything we know about Admiral Walsh. He's a good guy and tried to do as best he could. But mostly he was applying U.S. law. He thought that what was going on in Guantanamo was consistent with the Eighth Amendment, which is fine. Did not spend any time asking whether force-feeding hunger strikers, which is clearly humiliating, degrading treatment, whether it's torture or not, we can argue about it, but it's certainly cruel and inhumane, was consistent with Common Article 3, which was the standard that should be used. Kind of horrified, he wouldn't have thought that we had lower standards in the United States than at Guantanamo, but we do. Our prisons system is a whole other issue. My friend Scott Allen from Physicians for Human Rights has taught me a lot about prisons in the United States that I didn't want to know. But we do use restraint chairs on competent hunger strikers in the United States, but the physician is totally in charge. The warden cannot order the physician to do that, as can be done at Guantanamo. This is Justice Jackson. We've heard a lot about Justice Jackson. He said a lot of things, but one of the things he said at Guantanamo, at Nuremberg, was the most striking. He said, well, we got, is this a victor's justice? Is this, are we doing this just because we won? Or is it a double standard here? And he said it can't be a double standard. It can't be a victor's justice because, a great line, he said, if we pass these defendants a poison chalice, we put it to our own lips. And he got that absolutely correct. So what do we do? Let me just suggest 4 things, and then I'm done. The first is that, I suggested before, we actually need doctrine. Write it down. No physician in the military ever has to compromise medical ethics for the military mission. End of story. It's just like, we're going to hear of chaplains later, but I can't believe there's any requirement that a chaplain compromise his religious beliefs to be a chaplain in the military, or as we heard before, that lawyers compromise their upholding the Constitution or the rule of law. They're professionals in the military, to be sure. They're in a different setting, but I would argue They're professionals first, and that's why they're any good to the military at all. Number 2, no secret medical protocols, period, end of story. Number 3, physicians in the military should always have access, to always be able to call in civilian medical experts to help them. Not the case at Guantanamo. It's been like a nightmare trying to get civilian physicians in to see any of the people, including the hunger strikers. And finally, and then I'll end with that, and we can make this argument about law, but law is a little different because the law does change from state to state so much. There should be national medical licensure. There should be one place to get your medical license. It would be the same license for all Americans. I think that's, by the way, I think that's true under any reasonable system of national health insurance as well. But here it's especially important because the only check on the professionalism of physicians in the military are the state licensing boards. Everyone who practices medicine in the military has to be licensed by a state licensing board. Same is true of lawyers, I'm sure you know. And the only people who can actually judge them and take their licenses away are the medical boards. Our state medical boards have absolutely refused to get involved with military matters. I think they're wrong, but I certainly understand that. I've spent 6 years on the medical board in Massachusetts. They don't have the resources to do what they do now, and the idea that they're going to second guess the U.S. military at Guantanamo is kind of silly on its face. But a national medical board would, and that would also have, then we'd also have clearly articulated national medical ethics standards that everyone could see which were violated or not violated. There are always going to be gray areas. But nonetheless, so those are suggestions I have. I'm open to other suggestions, and especially want you to think about why hunger strikes, why breaking hunger strikes seems okay to do. And I mean that literally, since for the last 6 years, we've been daily force-feeding most of competent, some of them are incompetent by now, obviously, hunger strikers at Guantanamo, and not saying a word about it. Not saying a word about it. Thank you.
Good, almost afternoon. So I have to say that I feel a little bit like a tourist here. I am a practicing cardiologist. I spend much of my life doing human research, clinical research. I run a research center. Much of it is funded by the federal government. And probably not so dissimilar to at least what I heard you allude to earlier, David, about 5 or 6 years ago. I got a little tired of sitting by the wayside focusing on my professional activities and seeing what was happening with some of my colleagues in the broader health community, healthcare community sense, in what I felt was ongoing human rights violations. And so I became increasingly involved in an organization you've already heard a little bit about called Physicians for Human Rights. And somehow or other, Jesse Hill found my name on a report from PHR called Experiments in Torture. And that's why I'm here. But in any case, I'm going to talk about perhaps a step back a little bit and reframe the discussion, at least start by reframing the discussion of divided loyalties in the healthcare profession by first approaching the divided loyalties in the profession itself before you even get into issues around health professionals in the military. It's not infrequent. In fact, it's common to have divided loyalties in clinical medical practice. We all deal with it all the time. We have clearly first our obligation to the patient, and then there's conflicts. There's conflicting obligations, whether or not they're real or perceived, with all sorts of third parties, families, employers, insurance, the works. It's not a stretch to think it through. There are fairly common examples in the broader community. We have to breach confidentiality to prevent future harm. Psychiatrists need to do this if they know that somebody is in danger and that a patient of theirs has a real plan to injure somebody. There are reporting requirements for communicable diseases, and there are certainly clinical specialties beyond these which really are specifically which are more where divided loyalties are just intrinsic to daily practice. Obstetrics, you have two patients. You have a mother and you have a fetus, and as long as they're both healthy, there's no problem. Obviously, it's when one of them is not healthy that you do have competing loyalties. Organ transplantation, so in my clinical life, you have your patient who is, potentially dying of advanced organ dysfunction, and you have the rest of the community who's waiting for organs, and you need to actually be able to answer to both. But these types of, within the medical community itself, there really are very well-worn, tried and true systems with which to handle these, and they're mostly founded in fundamentals of medical ethics. For instance, in the transplant community, as the primary clinician, you advocate for your patient. You also sit on a multidisciplinary committee to make decisions for the broader community. And so you actually do have the opportunity to provide the advocacy voice necessary for your patient, but your colleagues will represent the broader transplant community. And then we get to military health professionals, and clearly these conflicts are unique, and I think more to the extreme. But they really do have to navigate some very, very difficult and sometimes irreconcilable obligations. And I have to say it's not as black and white as the example that George mentioned about being told you can't you can't treat an enemy patient, but there certainly are competing obligations, and when does the medical obligation become subordinated to the military obligation? You may have to declare troops fit for battle when perhaps your better judgment might say, you know what, they're not really fit for battle. You may have to modify what would be standard medical triage if you need to get troops back onto the field as fast as possible. You may have to let the sicker patient wait a little bit, which would never happen in an emergency room. You may need to be prepared, to be available to prepare or to be present in an execution, participate, which we've already heard about, in research that requires secrecy at this point in time. And in those cases, the standard sort of civilian regulations may be reduced, and they may be absent. And you may need to participate or advise in interrogation of suspects of torture, of terrorism. And then we come to the current lightning rod, torture in the war on terror. This is a particularly complicated situation, and frankly, there are few guidelines for healthcare professionals on how to deal with this within the military. I would actually agree with George when he said that, well, we'll get there. There are many competing values at play. And I think that this is a critical point in the healthcare profession at this point in time, because decisions that we make moving forward really will have very serious consequences in how we really do shape the future of our profession. So how do we negotiate divided loyalties? And I think that that any standard used to navigate these sorts of situations need to depend on fairness, transparency, respect for well-grounded medical ethics, and respect for human rights. I'm not going to get into too much of the bioethical framework, but it clearly is the most grounded historically in the medical profession, and it relies on the 4 tenets of autonomy, beneficence, avoiding causing harm, and fairness, justice. It's complemented by the human rights framework, which claims stem from international consensus around really moral principles that are considered universal. So Article 12 of the International Covenant on Economic, Social, and Cultural Rights states that every human being is entitled to the enjoyment of the highest attainable standard of health conducive to living a life of dignity. Now this imposes 3 fundamental obligations on governments. One is to refrain from interfering with the right to the highest attainable standard of health, respecting the individual. One is to protect this right, to prevent third parties from interfering in this right, and the other is to adopt any appropriate steps toward realizing the right to the highest attainable standard of health. International human rights law, now here I'm really stepping into your world, not mine, but bear with me for 2 seconds. International human rights law grants legal obligations to governments, and as such, military officials as agents of the state operate under these obligations. Article 5 of the Universal Declaration of Human Rights states that no one shall be subjected to torture or cruel or inhuman or degrading treatment or punishment. So this is obviously an aspirational document, but there are certainly covenants and international agreements that operationalize it. One of those is the Convention Against Torture, and we, along with 140 other countries, are party to the Convention Against Torture. Within this convention, CAT defines torture as any act which causes severe pain or suffering, whether physical or mental. Don't forget that word severe. Is intentionally inflicted, is done for such purposes as obtaining information, confession, punishment, all sorts of nasty things. And it's inflicted by or at the instigation of a public official or somebody that's acting in their behalf. Article 4 of CAT requires that parties ensure that all acts of torture are considered criminal offenses, and that they're subject to appropriate penalties. And the prohibition of torture is absolute. So how did we get here? So in 2002, Rumsfeld, who seems to be coming up a fair bit, approved a list of interventions that were defined as enhanced interrogation techniques. These included stress positions, temperature manipulation, threats of harm to person, etc., sleep deprivation, isolation and other sensory deprivation, humiliation, shaking, slapping, and sensory bombardment. These interventions we had a fair bit of experience with these interventions. We have experience with them because they were used during the 1950s to train, it's the SEER tactics. They were used during the 1950s to train our own military to make sure that they could deal in situations where they were prisoners of war in other countries. We've just switched the roles a bit. And it's clear, we know, I mean, the whole purpose of training our military was to make sure that they wouldn't break under these conditions, or at least we could try and minimize the breakdown. In this case, the purpose is to break down the detainee. And these interventions have substantial psychological and physical trauma that are long-standing and severe. And by the way, the other thing that I do is do medical evaluations of people from other countries who've been victims of torture and other countries who are applying for asylum. So I've unfortunately had plenty of experience seeing the long-term, both physical and psychological impact of torture. Again, and these are the health consequences, obviously, of just of psychological torture. There are, as you could imagine, a myriad of consequences, long-term consequences of physical torture. So almost 2 years ago now, Obama issued an executive order mandating, around the time we were all excited that maybe he would close Guantanamo, that all interrogation practices had to comply with the Army Field Manual. There are a couple of issues with the Army Field Manual, and one of them is that in Appendix M of the Army Field Manual, there's actually a loophole where some of these interrogation techniques, I mean, we can get rid of the infamous waterboarding, which is terrific, but there are a number of these other techniques that actually remain acceptable. So now we get back into, so what has been the health professional's role in these interrogation techniques? Healthcare professionals have been used in teams sort of cloaked in the name behavioral science consultation teams. So these behavioral science consultation teams were used to essentially redefine these particular types of techniques, which in historical times were considered torture, as enhanced interrogation techniques. And the way this was done was they were asked to define what exactly is severe physical pain, mental or physical pain. And so they were brought into the interrogation process, required to monitor detainees and define the point at which they felt there was too much physical or emotional harm. And then if there was a little less than that, then okay, it's an interrogation technique. So essentially, by linking the medical professionals into this process, not only did it require medical complicity, but it also created a legal basis for being able to continue these activities. So how has the data, the evidence that healthcare professionals have collected over this period of time during interrogations been used? The information has been used directly on the detainees themselves. So specific profiling of their vulnerabilities and social and cultural mores to advise the captors specifically about how to maximize the physical and psychological stress for that particular detainee. Medical professionals collected extensive data on both on waterboarding in general, but both with regard to the particular waterboarding session, or whatever you'd like to call it, to determine its safety, providing what was considered medical oversight. I use the word safety clearly in quotations because it is absurd to use it in that context. But there was even this other intriguing twist. There was medical professionals were also asked to evaluate different types of waterboarding techniques. So, should we be using water? I mean, it's a ridiculous, fact that I'm standing here talking about this. It's absurd that we were doing this. Should we be using water, free water, which dilutes? There certainly are physiologic reasons why you might be curious about this. Or should we be using saline to avoid diluting the physiologic balance in the body? It is insane that we're sitting here talking about this, but it was done. A lot of systematic data was collected about this, and actually it was then applied to tailor future protocols for ongoing waterboarding at that time. Data on susceptibility of detainees in terms of the severity of pain, again, was used to sort out the protocols. Should they be used in succession? Should they be used simultaneously? This is not just monitoring, stretching the term safety, monitoring safety. This was really protocolizing these types of techniques. And I could go on about that for quite some time. So this information was then used, as I was saying, essentially to sort through and to standardize what are the durational limits for various types of exposure to extremes of temperature. What are the limits on weight loss? At what point do you end up compelling a physician to force feed? What are the quote-unquote safe thresholds for exposure to extreme noise, et cetera, and durations of containment in boxes, small boxes? I think we've actually covered that. So in summary, information gathered by medical professionals was used both to help interrogators determine the legality of their actions, but also to establish policies for future interrogation. In no way did any of this information serve any clinical purpose. The involvement of medical professionals was designed to further national security objectives, and it was clearly not in the interest of the detainee, who theoretically was who should have been the object of their professional monitoring. And physicians, you know, we take an oath. We have an obligation to do no harm. This has been such a twisted process that suddenly that obligation is shifted toward doing no harm that would create severe pain. It's actually interesting, your couple of slides and the discussion earlier this morning about the effects of involvement in torture, because one of the things that I certainly didn't really think about when I was first starting to get involved in this sort of work was anything about the effects of involvement in torture beyond the detainee. But you know, what we saw this morning is there are profound effects on the professional who is assisting in any part of this process. And what we're also clearly seeing as a healthcare profession as a whole is the impact on the profession. It's a breach of medical ethics. It violates domestic and international law, and it profoundly erodes what trust we do have both between patients and in the broader community. So what do we do? I think we do need to reassert our role purely as caregivers and researchers, but I agree, research has to be transparent. We have to return to adhering to, well, defining established medical ethics principles that apply, in fact, to, I think we actually need to, I should rephrase that. We need to apply medical ethics principles that are well worn to healthcare professionals in the military. And we need to refer these ethics and ethical and human rights principles to be able to compete, to negotiate competing loyalties. And before I turn it over, I just want to end on a note, which I actually thought was sort of interesting. Well, I hesitate to say there's anything useful that's come out of what's been going on in the last almost 10 years, but it has provided a lightning rod, which I think actually is useful in terms of recentering and perhaps using this opportunity to create this framework that's so needed. This is a quote from an article that was published in Lancet Student. So it's a British medical journal. It's the student version of the medical journal. And it was authored by 3 medical students, actually from Mount Sinai, where I work, who actually have been part of a growing group, a national group of students who've been involved in various organizations, medical students involved with various human rights organizations. And they say, physician-assisted torture is so egregious a violation of medical ethics that it justifies a definitive response. As medical students and young physicians, we're compelled by beneficence and pride in our chosen profession to help end this shameful practice for good. We hope that other states in our country will follow New York's example. Oh, I should reference that in a second. Will follow New York's example with their own laws and measures, and that we will see medical educators rise to the occasion by placing a greater emphasis on professional ethics and human rights. And what I should have said is what they were referencing is a bill that's been proposed in New York State that would require the state to hold healthcare professionals who are complicit in any torture violation accountable. And actually, that would be the first law of its kind in the country.
Okay. I'm going to start with a quote from the International Committee of the Red Cross, because I want to remind us that in much of the world, some of the issues about where medical professionals' loyalties lie is pretty clear and hasn't been muddied as it has been in our country. So I just wanted to give this floating out there as a context. The ICRC interviewed 14 detainees at Guantanamo who had been tortured, and they concluded this about the participation of health professionals. Any interrogation process that requires a health professional to either pronounce on the subject's fitness to withstand such a procedure, or which requires a health professional to monitor the actual procedure, must have inherent health risks. As such, the interrogation process is contrary to international law, and the participation of health personnel in such process is contrary to international standards of medical ethics. In the case of the alleged participation of health personnel in the detention and interrogation of the 14 detainees, their primary purpose appears to have been to serve the interrogation process and not the patient. In so doing, the health personnel have condoned and participated in ill treatment. That's very clear, but it is, and there seems to be no problem ethically with holding that position, except that it is totally contrary to the position of intelligence health professionals in the U.S. military. And I will tell you the story of how that evolved and where we are today. But I just want to start, my second point that I want to begin with has to do with what I think is the value of divided loyalties. Divided loyalties is an interesting phrase because it has a double meaning. On one level, I believe, and I'm speaking now as a child of Holocaust survivors, that it is essential. It is the essence of ethics to not be beholden to institutional or governmental decree, but to always have some divided loyalty, some standard outside of institutional or governmental decrees to be beholden to compare and contrast that to. And the Nuremberg laws and the situation in Nazi Germany certainly clarifies why that is the case, why divided loyalties is such an important internal dilemma that we always have to struggle with. But of course, speaking as a Jew, the idea of divided loyalties is often used as a term of suspicion. That, if you have divided loyalties, will you join a fifth column? And that dates back to Exodus, where the Pharaoh and the Egyptians said, "Let us deal wisely with them," meaning the Jewish slaves, lest they multiply, and if it should happen that we are at war, they will join our enemies and fight against us. So this question of dual loyalties is such an interesting one because it has two very different connotations. Okay, and I don't have to go into the codes of ethics and how, especially for medical professionals, but certainly for lawyers, certainly for clergy, there are standards of ethics that help us to have the ethical divided loyalty that I think is essential to good practice. But what I want to talk about is how that has collapsed in the United States over the past decade and maybe even longer. And I think that arises out of this concept of the the manipulation of the term American exceptionalism. What American exceptionalism has come to mean is that the United States is not beholden to the same standards as other nations, that there's something exceptional about us, that we do not have divided loyalties or some separate international or ethical code. We ourselves are free of that. Our laws, our American personality makes us unique in this very way. And that is evident when it comes to international law, where the U.S. has been among a tiny handful of nations that refuse to ratify the authority of the International Criminal Court, the International Ban on Landmines, the Convention of the Rights of the Child, and most importantly for our purposes here today, the exceptions that the United States took to the UN Convention Against Torture. We are a signatory to it, but we had reservations which say that we only agree to follow the CAT insofar as it is consistent with our own constitutional prohibitions against such behavior. And if it conflicts with our Constitution, in other words, our domestic law, we don't have to follow it. And that was the basis upon which you and Bybee justified torture, justified these acts in the CIA and the military, the enhanced interrogation techniques, as not in violation of the torture, cruel, inhuman, or degrading treatment. And this exceptionalism took off after September 11th, where presidential directives and Justice Department memos simply undermined all our being beholden to international standards such as the Geneva Conventions, rules of law as coerced evidence, indefinite detention. All of these standards went out the window in the so-called global war on terror. And unfortunately, for my profession, psychologists saw this as a career opportunity to join the rhetoric and the practice of changing the mode of interrogation to include enhanced techniques, to include torture. You've already heard that these psychologists came primarily from the Joint Personnel Recovery Agency, which was responsible for the SEER training. They, and I don't have to go into that, but particularly it started with two psychologists, Mitchell and Jessen, who were SEER psychologists. They were given the so-called Al-Qaeda resistance manual to study, and they decided that they were going to use our resistance training techniques to counter their resistance training techniques and turn up the heat using Rumsfeld's language, since he's our anti-hero today, he's our villain, to take the gloves off, or to use Cheney, I think the other Lucifer in the story, to go cross over to the dark side. Okay, so the first experiment in torture was Abu Zubaydah. He was captured and taken to a CIA black site, and Mitchell and Jessen were hired at a fee of $2,000 a day to oversee the first torture process. In the beginning, they used some of the techniques we've spoken about: the nakedness, tied him to a chair, only fed him liquids, extreme cold, sleep deprivation. But the White House wanted things to get more serious. And this is one of the things that I think we have to be clear about. When we talk about how the torture became widespread in places like Abu Ghraib and Guantanamo, we cannot talk about the lack of oversight. We have to talk about the extreme oversight. In fact, the first torture of Abu Zubaydah was observed and directed by the principals group in the White House, which consisted of Vice President Cheney, Condoleezza Rice, Rumsfeld, Colin Powell, CIA Director George Tenet, and Attorney General John Ashcroft. They were apprised of the techniques. They together decided on which techniques were going to be used and in which order and how simultaneously. And there were tapes made of the torture. They saw them. Those tapes have been destroyed so that we don't have the visual anymore, because it causes too much guilt and problems. But this is not a matter of certain circumstances causing extreme and unusual processes of interrogation, abuse, but a culture of abusive interrogations coming from the very, very top. But the role of psychologists is what I'm interested in elaborating. Mitchell and Jessen worked very closely with John Yoo, so the psychologists and the lawyers got together to justify the torture according to the reservations to the UN Convention Against Torture. To prove that, as you argued, they did not cause severe and lasting harm. How do you prove that they don't cause severe and lasting harm? You consult professionals who read the literature. You have psychologists and physicians present, and you make sure that there is that it doesn't look like that was your intent, to cause severe and lasting harm. Mitchell did the literature survey. He actually did a test report on Abu Zubaydah, which claimed that he was strong and resilient and would bounce back. This is from the test report. Zubaydah is a highly self-directed individual, possesses an air of self-confidence, self-assurance, and authority, excellent self-discipline. His background does not indicate that he has any history of mood disturbance or psychiatric disturbance. Any occasions of stress will likely last a short time. Okay, he did a psychological testing which totally supports that he's the perfect candidate for the first experiment in torture. You responded back in his second memo, specifically permitting the torture of Zubaydah. According to your reports, Zubaydah does not have any pre-existing mental conditions that would make him likely to suffer prolonged mental harm from your interrogation methods. He seems remarkably resilient and confident that he can overcome adversity. These two seem to have a very friendly relation, because the test report, when it was sent to you, had a note that said, where's the note? Here's the psychological assessment. Please feel free to call me at home or at work, whatever, thanks. There's a certain casual connection between the psychologists and the lawyers in this. Okay, so but it turns out that this memo was, the test report seems to be completely fabricated, because previous reports by the FBI seem to find Zubaydah to be quite pathological. They called him insane certifiable split personality based on their assessment of him. So for me, I just want to look briefly at how many ethical practices Mitchell broke in preparation for the torture of Zubaydah. He provided objective literature review to the Office of Legal Counsel to assess the danger and therefore the legality of the techniques, while he himself was under contract to implement those very techniques. He performed a psychological test while personally standing to gain if the results went in one particular direction. He developed a personal relationship with the lawyer writing the legal argument that would provide a defense for the torture he was being paid to do, and provided support in a direction that would indemnify himself legally, not to mention other minor details like the proscription against doing harm, deception, the need to have competence, non-malfeasance, et cetera, et cetera. Okay. Now, it was not only these lone psychologists who were working together with the government, the Office of Legal Counsel, the Justice Department, and the CIA and the FBI to create and further the torture techniques. The American Psychological Association itself worked with the CIA and the FBI to justify the role of psychologists in these interrogations. Starting with Susan Brandon, the senior psychologist for the APA, started meetings with the FBI and the CIA at very high level, but classified in November and December of 2001. Martin Seligman invited a group of Israeli and American psychologists to discuss the role of psychology in counterterrorism in December 2001. Mitchell was present and spoke to Seligman about learned helplessness techniques, which he then implemented by putting Zubaydah in a box, quite a bit like Seligman's dogs in his learned helplessness experiments. The APA changed its ethics code, and actually changed it exactly the same month that you changed the rules on enhanced interrogation techniques. The new ethics code said that if there is a conflict between ethics and law, or military, I'll read it exactly. If psychologists' ethical responsibilities conflict with law, regulations, or other governing legal authority, psychologists may adhere to the requirements of the law, regulations, or other governing legal authority. In other words, the APA ethics code was no longer an ethics code, but a legal document. It was beholden to the law, therefore it had no independence. They informed consent was no longer necessary, and deception was also possible if permitted by your institution. Okay. I'm going to try to be brief about the rest of this. The same thing happened at Guantanamo in the DOD, not only the CIA, but there was a standard operating procedure and which codified the use of these techniques for every detainee as they arrived, including isolation. To quote the well, I can't quote it because I don't know where I put it, but okay, so but basically this was operationalized and codified at Guantanamo as well by psychologists. The chief psychologist of the Joint Intelligence Groups, Larry James, claims that he wrote the behavioral protocols for these incoming detainees. That all of this caused a group of psychologists to try to change this, to try to change the ethics, to restore the ethics code, because it became pretty clear to us that the legal justification for torture required the presence of medical professionals. That was required, that if you in order to prove that it was not torture, you needed a medical professional present to say that this does not constitute severe or lasting harm. And so every single torture enhanced interrogation had to have biscuit psychologists and psychiatrists present, behavioral science consultants present. So we decided that if we could prohibit health professionals from acting in this role, we could stop the torture. And the American Medical Association, the American Psychiatric Association came out clearly against physicians playing that role. The American Psychological Association put its interrogation psychologists on a committee to determine APA policy, and naturally they decided that psychologists had an obligation to participate in these interrogations. But we fought the APA. We thought we had won. The membership passed a referendum saying that no psychologist could work anywhere that violated international law, the Geneva Conventions. We changed 1.02, which was the clause in the ethics code that allowed you to follow the law over ethics. But we thought we'd won, but we actually hadn't, because there was a new biscuit policy put in place in April of 2009 under the Obama administration. It was authored, or co-authored at least, by one of the psychologists who'd been involved all along, Morgan Banks. And here are some of the here's some of what the new code requires. First, biscuits must be volunteers who understand the nature of the mission, the shift from non-combatant to combatant status, professional ethical controversies and their potential ramifications, and, if opposed to the role, be afforded the opportunity to deploy in a non-biscuit assignment. In other words, these are not non-combatant medical professionals anymore. They're combatants, and they only want volunteers to do this role if they support it. So there's no ethical, exterior ethical commitment opposed to this kind of behavior for biscuits. Health professionals do not qualify for special status according to the Geneva Conventions. They advise command authority for determinations of release or continued detention of detainees. So now they're responsible, the health professionals are responsible for the indefinite detention or dangerousness of detainees. Somehow that's a psychological or medical issue that psychologists have to be able to adhere to. A biscuit's function in intelligence interrogation and detainee debriefing assessment is to evaluate the psychological strengths and vulnerabilities of detainees and to assist in integrating these factors into a successful interrogation debriefing process. You have to exploit vulnerabilities. That's the job. And you also create the detention environment. Biscuits assist in ensuring that everything that a detainee sees, hears, and experiences is part of the overall interrogation plan. And this is the most frightening of them all, the final one, which is new under the Obama administration. The Department of Defense requires that all military professionals perform their duties in an ethical manner, consistent with their professional ethics, although they are neither required to join nor adhere to the policies of any specific professional organization. The MedCom OTSG has carefully reviewed the positions of the relevant professional associations and their ethical guidelines, as well as the various concerns raised by interested parties, in consideration of the safeguards, including those for humane treatment of detainees, the consultative nature of the work of biscuit personnel, reporting requirements for all personnel, as well as the clear distinction between healthcare functions and biscuit consultation. The OTSG determines that performance of behavioral science consultation duties as described herein is deemed ethical practice consistent with medical and psychological ethics. So if there is a contradiction with your professional code of ethics, it doesn't matter because the military has deemed the practice ethical. And it goes on then to review the ethical objections of the American Medical Association and the American Psychiatric Association, and through incredible sleights of hand, which I'm not going to go into, justify biscuit practice basically by upholding the duty to society over the duty to the welfare of the individual. So I want to conclude with a psychoanalytic concept. I'm a psychologist, psychoanalyst, and I want to bring in the question of dispositional versus situational response, because there's a concept in psychoanalysis which is called the concept of the third, the idea that there is something that is external to simple power and desire, the execution of power in the interest of desire. And you could call that the conscience, you can call that social norms, you can call that ethics, you can call it morality, you can, but the whole idea of what makes human beings is that they have developed some check on their desire, on their impulse. And it comes originally, according to Freud, from the incest taboo within families, but it is made socially expanded. So the question for us has to do with this third. What is the third? What are we beholden to that is external to our desires, our narcissistic beliefs that everything we want is okay because we have the power to execute it? And so in terms of the dispositional versus the situational, it's more than just dispositional. It's more than just a question that I personally wouldn't do such a thing. It's an idea, according to the psychoanalytic concept of the third, that there is a social disposition which interferes with giving vent to circumstances of the situation. However, what we have seen in this country is a collapse of the adherence to the third. In our country, in the United States, the great third, the great external source that we appeal to is the Constitution, as David Frank spoke about. The Constitution always allows us some external comparison point to remind us of our belief system, to remind us of what we think is appropriate action, ethical practice, legal practice, so that we don't fall into the emotions of the revenge, of the moment, of the power of our administration saying we are not beholden to any third, we're not beholden to international law. So our psychological question and our legal question and our question as civilized human beings is how do we restore the respect for an independent source to compare the impulses, the orders, the rules of government, when those have been collapsed into simply an articulation and a justification of power because I say so and I have the power. And that's our job, to reinstitute morals, ethics, law, constitutionality. And that's, I think, how we have to begin our fight to reinstate the United States as part of a moral universe. Thank you.